We've talked a lot about mediation and how you go about doing a mediation, when it takes place, or how it takes place, and the process. We know it's all about process, right? So that's crucial. We've talked about what mediators, or what a good mediator's role should be. Talked about mediator styles. Talked about how you should prepare for a mediation, which is very similar to preparing for a negotiation. But you'll have uploaded on Twin this International Trademark Association mediation checklist. And this checklist, while it's particularly pertaining to trademark issues, is instructive because really these are the things that we ultimately, and you ultimately, when you are speaking with your client and strategizing about your case, you are going to make decisions and recommendations for strategy based upon asking these questions and then arriving at the answer based on what your client's needs are and what the circumstances are of the underlying dispute. So I thought I'd run through these real quick, but it's really instructive, I think, on the main points that you want to think about whenever you're doing a mediation, whether it's for any type of case. It's not just trademark, obviously. This could apply to anything, but just looking at, in this case, the mediation, whether to choose it, under every one of these headings, there's a pro and there's a con. So let's just look at some of the basics in this, and you can see where that would be applicable to just about any other type of case, whether it's a family law dispute, whether it's a construction dispute, whether it's some sort of business transaction dispute, or whatever it might be. Let's look at number one, the threshold question about whether mediation makes sense. So on the pro side, settlement of the dispute is most likely inevitable, and even if it might only be on the courthouse steps. The client believes that we should win, but nothing, of course, is certain. On the flip side, the con side to that, under threshold, that a settlement is simply not conceivable at any juncture during the pendency of the litigation. And one or both of the parties have reasonably good reason to believe that it's a virtual certainty that they will win in litigation, which that would be a rarity for anyone to really feel that strongly, or to have a basis to feel that strongly, but it could happen. So first thing, right, threshold makes sense as the initial question. Then looking at the relationship of the parties, which is always a key factor, right? Because it makes a difference if there's really no concern about future relationships or future dealings. It's not necessarily as significant in terms of mediation and the benefits. But so again, with the Trademark Association relationship on the pro side, we want to preserve important business or other relationships with the other side. And in this case, they're using as an example licensor, licensee, franchisor, franchisee, supplier, distributor. On the con side, no matter what the outcome of the dispute, we do not expect to deal with the other side again. Now, I mean, there are certainly situations where that kind of scenario in terms of relationship will exist, but oftentimes the cases that you'll have, for sure, always, or most of the time in family law cases, you'll have ongoing relationships, obviously always with children, but even some other types. So it's definitely something to consider along with thresholds. So then we get to the third consideration, right, which is publicity and confidentiality. On the pro side, the issues involved are of a sensitive nature and would require disclosing trade secrets or competitive information, proprietary information, production of sensitive documents, or testimony of senior management. That's on the pro side, suggesting that we would like to maintain confidentiality and limit publicity. That's what you do in mediation, right? On the con side to that, the issues involved are unlikely to require disclosure of confidential or sensitive matters, and publicity concerning the underlying dispute would not have any effect on us, and even a defeat would be of minimal harm. So there's your pros and cons on publicity and confidentiality. It would seem to be rare to think of a circumstance where somebody would not want to preserve confidentiality. I mean, in a lot of cases, it would seem that confidentiality would be a significant concern and something that would tend to lead one to look at mediation in a positive light. But how about the effects of litigation? So on the pro side, we need an early resolution so that we can plan and act accordingly, and that might be, again, under a trademark scenario. There's a trademark coming out, the campaign is already in use or about to be launched. Litigation expenses would be a significant burden, and they may be disproportionately large. Just exactly what we talked about earlier about some of the benefits to mediation, and that's certainly time, limiting time, making resolving a case much more quickly, and significantly lowering and reducing expenses and the cost of litigation. So that makes sense there. How about the nature of the dispute? The legal or business issue, this is on the pro side, of course, the legal or business issues involved are highly technical or complex, and trademark expertise is necessary to thoroughly understand the merits of the dispute, and there is a high risk of erroneous judicial outcome, particularly with a jury. So, very important to consider that. And then on the con side, the issues involved are relatively clear or turn mostly on credibility of fact witnesses. Well, then it wouldn't be a problem to submit the case to a jury so much. We do not know where the case might be, or the court does not have an ADR program. That would be on the con side of that. So, in looking at the nature of dispute and considering the concern about the complexity of the issues involved in trademark disputes, although we talked about mediators not being attorneys, or that they don't always have to be an attorney, and that frequently that might be a benefit because you are really looking for someone that's more committed and concerned about the process than is necessarily worried about the specific knowledge of an area of law. Now that would be a completely different situation in an arbitration, where you actually have the arbitrator making a decision based on his or her knowledge of that and expertise in that area of law. But here, not so much, but when you have something like a trademark matter, a patent matter, something where there are pretty significant complexities, that would be a time when I think you would want to look much more closely at getting a well-trained mediator that was an attorney and did work in the area that you're considering, because the problem is most mediators that are not attorneys have, through experience, been apprised of issues impacting a lot of different areas of law. But in these types of cases, that does require a level of special training that very few people have. So what you would have in this case of a mediation involving something that complex, you would have to spend more time basically training the mediator in certain areas that the mediator knew nothing about. It would overwhelm any benefit that you had to going through the mediation, because it would probably take days, weeks for a mediator to ever get up to speed with the complex issues involved. So when you're looking for a mediator in a more complicated type of dispute, it's probably going to make more sense to have someone with a background in that, and hopefully a significant background. All right, we have nature of desired resolution, right? That's another area we want to look at pros and cons. So on the pro side, we would be satisfied with a resolution that a court could not grant. So for example, modifying the other's trademark, advertising usage, restrictions on channels of trade, modifications to a contract, those kinds of things. We need, and this is a pro, we need to control the outcome because the risk of a damaging all or nothing court decision or adverse precedent is high. Again, we've talked about all these. Extraneous business considerations dictate a speedy resolution. Some examples would be if we were expecting to go public soon, or selling the company soon, or having anticipating a merger, acquisition, something like that. The dispute, again a pro, the dispute has ramifications in international markets, and we need a solution that provides parallel resolutions with the same party in multiple jurisdictions. So that is, those are on the pro side. On the con side, we need, or the other side needs, a resolution that only a court could grant. Example, where there's legal precedent, significant legal precedent, right? And or immediate injunctive relief. Also on the con side, it's important to win in litigation, to send a deterrent message to third parties, or to be viewed by third parties as publicly vindicated in this dispute. But remember, that mindset, you better be darn sure that if that's your position, that you have all the ammunition that you need to succeed in the litigation. So that's a risk, because it's already established multiple times. It's when you go to trial and you go to court, it's all or nothing. There's no splitting the baby. And so if that's your position, that we have to win, well, you'll realize that no one can ever tell you you have to win. I mean, they can tell you that, but there's nobody that can say, I am going to win with 100% certainty. I mean, you may know people that say they've won every trial that they've had. There are situations where people can cherry pick cases that they try, where the evidence is reasonably overwhelming in their favor, and those are times when you can see people that have an unblemished track record with trials. But if you have someone who tries many, many cases, you're going to have wins and you're going to have losses. And cases that you thought you might have won, you might lose, and cases that you thought you might lose, you might end up winning, because it's a game of chance. Even when you have ridiculously large amounts of beneficial evidence and the other side's witnesses are questionable, you never know when you're dealing with a jury. So to make this statement as one of the cons, you better be able to back that up. So, and then finally we have decision makers, right? And on the I don't know what these symbols really are, but just little squiggles. But for decision makers on the pro side, we have that the decision makers on one or both sides are probably mostly unfamiliar with the facts or merits, and counsel's or attorney's presentation and a neutral's participation in ADR could be educational and promote a more realistic assessment in addition to diffusing hostility between the parties or counsel. On the con side of that, we believe that our opponents' top-level decision makers have firmly decided against settlement. So what that really is, what it means is that you know that if you go to a mediation or to negotiation or some type of alternative dispute resolution vehicle, you have a pretty good sense that the other side is not committed and that they're not going to come to the table and operate in good faith. And if you really believe that's the case, then it probably is not cost effective or time effective to go forward on that. Another con is that the attitude of the other side is one of extreme hostility, contempt, or distrust. So, it may be a situation where there just simply is no alternative for you but to go forward on litigation, and that can happen. But generally speaking, the benefits under all of these categories generally are going to far outweigh the cons. But again, it depends on a lot of factors, which is why it's good to have this kind of matrix to be able to look at and work through, because if you think about it, this basically applies to just about every type of case that you'll ever encounter, from the smallest case to the largest. It works. And then finally, under the section for attorneys, attorneys for the other side are unsophisticated in trademark law and settlement approaches. A third-party neutral's participation could be instrumental in opening dialogue or communication. Another pro is that in-house counsel has a grasp of the issues and/or appreciates the value of avoiding significant litigation. On the con side, under attorneys, the attorneys for the other side are on a contingency fee arrangement or have an emotional or commercial interest in the dispute. So again, when you go through these and you think about it, normally, and this is going to be true, if we already know that 97% of cases that are filed in court are going to settle at some point during the pendency of the case. So it really makes sense that when you think about all of these areas, that the overwhelming pros far outweigh the cons or the negatives. The positives far outweigh the negatives. But there are situations that can arise where you want to consider on your matrix, because there may just be enough significant negative aspects that it might make you reconsider the benefits and time and expense of proceeding with mediation. And we didn't really talk about the expense involved in mediation. Now, when you have a negotiation, the only expense that you're going to generally encounter is the cost of renting a facility if you're going to go through maybe a commercial facility. But there's really not a lot of other expenses associated with the process other than the time of the attorney. Now, in a mediation, that's different because typically the mediator has a minimum number of hours. There's usually an agency fee that covers the agency where the mediator works out of, and of course there's expenses that are associated with any additional hours the mediator puts in. But as with all things in mediation, one thing that all mediators want to make sure of is that the costs are borne by both parties that are part of that mediation, because when both parties are paying half of the expense, they both have a stake in the outcome, right? I mean, if it was free, then it really wouldn't make much of a difference to anyone. But when both sides are having to fork over the money for the mediator, for the facility, and all these other things, it really puts some skin in the game for both sides. Now, if somebody has a problem on one side or the other where they have some sort of agenda as to why they don't want to move forward on mediation, well, then that may be a problem that would be difficult to overcome. And whether both parties paid for mediation or not, you still may not be able to come out with a successful outcome because one side isn't operating in good faith. So the expense for a typical mediation can run anywhere from $2,500 and beyond. It just depends on the experience level of the mediator, on the facility where the process takes place, and but again, when you have an expense like that, you're going to be splitting it in half. So if it's $2,500, one side pays $1,250 and the other side pays $1,250, and so it may not be as big of a problem. But it's just something to recognize that there is an expense involved, and And again, the oft-used phrase, "you get what you pay for," certainly applies in the mediation world, because that's an area where you don't want to look for deep discounts, or really think too much about buy one get one free or anything like that. You don't want coupons or anything. When you want to, your concern is the caliber, quality, and experience of the mediator, and knowing either through your experience with that person or through the counsel of other people that you rely on, their opinions. That is what should drive the train when you're making and going through your due diligence, making a decision about who to use for mediation. So, but I thought that the Trademark Association Matrix is a valuable tool in terms of just thinking about all of these headings, because all of these headings really can be significant in any area that you are trying to resolve a dispute. Now, what are some of the main areas that you could use mediation in a meaningful way in your career? I mean, it probably would be easier to try to identify an area that wouldn't make sense to use mediation for. But if you think about the plethora of disputes that exist, I can't really think of too many areas where there would really be any hesitation in using mediation as a tool or resource as you consider creatively resolving a dispute. So that would be true, obviously, in family law cases, and that's why in basically all custody cases and most divorce cases, mediation is mandatory. Cases where you have landlord-tenant issues, cases where you have construction disputes, cases like that tend to drag on forever in litigation. They're horrible in terms of they eat up costs for the clients. It's a nightmare. But pretty much any area that you can conceive of, personal injury, multi-party litigation. So in other words, you have multiple parties that were involved in a wreck where one car kind of started a multiple car pileup for whatever reason, and you have multiple injuries, and you have multiple liens, and you have multiple claims, and multiple insurance companies, adjusters. Of course, the one thing you'd have to make very certain of in that scenario is that whenever you do have a mediation, you make sure that every one of those companies is accounted for in terms of checking off that someone is present with authority, settlement authority, because otherwise it just isn't going to work. So, but again, almost any medical malpractice, any sort of discrimination case, gender discrimination, racial discrimination, because a lot of those types of cases too will, at least one side is going to certainly want to consider the benefit of confidentiality. In a lot of these cases, there could be ongoing relationships in the future, or at least the potential of ongoing relationships that you are hoping won't be fractured through the process of litigation. And you know that if you go through to the conclusion of a trial, if you have a relationship, it will be fractured, and in some cases permanently fractured, to the point of no return in most of those cases, because it's just not a good thing to preserve relationships. But all of these things are really just can be used in almost any type of dispute, and provides a good framework when you are considering whether it makes sense to use mediation or whether it does not make sense. And as I said, with a few exceptions, I can't imagine a scenario where it really wouldn't make sense, other than as in the con section of this matrix, where somehow you know this, that the other side is absolutely recalcitrant to any sort of settlement discussion. You may have someone that is a zealot that owns a company on the other side, or is a principal in a company on the other side, or for some reason there's past experience that you can look at as an indicator that that individual or maybe the group that owns a business is not going to change their view, that they've maintained a certain view for years, and no matter what a mediator says, no matter what the plaintiff says, no matter what you say, no matter what a federal judge says if the case is in federal court, it doesn't matter. It will not matter to the other side. And so if that's the case, that's probably going to suggest that mediation just may not be the vehicle that you want to look at, because there's enough of an expense associated with mediation where you don't want to be cavalier about using it in a situation where you have a very strong sense that it will be a futile exercise. And we don't like to engage in futile exercises as attorneys because that's just too expensive, not just for money but for time. Nobody has time like that when you're practicing law to be running after things that make no sense based on the information that you know. So, and if it's information that you gained from a client or some other way, then you may want to verify that information or just determine that it sounds legitimate, because sometimes people may have a view of a company they work with based on the fact that they haven't really had dealings directly with the principals of the organization, but you might have had dealings with them in the past or know people that have, and in that scenario I might do a little more checking on whether the concern was really valid. So if you don't know that the concern is accurate and genuine and credible, that's something you might want to follow up on a little bit and do your own due diligence, because as I said, there's very few times that you can really point to any type of dispute and say, well, that just would not lend itself to resolution this way, and so something to think about. We've talked quite a bit about meeting with the client, and we talked about it in the negotiation preparation stage and also the mediation preparation stage. And so one thing that I drafted quite a while ago was just an example of a client meeting outline of things that you might want to consider. And in this particular case, it involved a personal injury matter. But it's just kind of an outline that you might want to look through to think about how this would apply into other situations like family law disputes or other things. But so, for example, this is a case, as I said, involving personal injury. So there's certainly many more questions that would arise from this. The idea about an outline like this is that you don't want to be wedded to 20 pages that contain 300 questions, because if you're doing that, then you know in your heart of hearts that you do not have the capability of actively listening. And the flip side of active listening, or the result of active listening, is that you're able to convey back the information in a summary manner to the other side, or to whoever you're listening to, what they said, but in a way that you own. So if you're looking and reading every single question on page after page after page, when you hear a client say, provide an answer that's equivocal, if you weren't looking at 20, 30 questions, you would pick up on the hesitation, on the equivocal nature of the response. You would pick up on cues, because we all get those cues, but you can't possibly do that if you're reading questions. You cannot engage in the active listening manner that you must in order to understand what your client's saying. But, so in this case with a personal injury claim, this would be questions. On the first meeting, I don't know, you could certainly ask these questions at an initial meeting, but at the initial meeting, don't forget that one of the key aspects is to get a comfort level established between you and the client. And that comfort level doesn't come from you giving the client a martini or mixing cocktails. It really comes from you not only listening to what the client is saying, but also really taking some time out to talk about this process, the overall big picture process. You don't have to get into the weeds and get into the nuances of a particular area, but it's good for the client to hear you talk about the process, because it makes the client feel confident in your ability, while also helping the client to understand what he or she can expect through this mire of strange new things that they probably have never seen before. So to get to the questions, some of the major questions that I'd want to touch on, and these questions are really designed mostly to elicit more open-ended responses that might lead me down to other questions. So I might get away from these, but then I'm going to come back and make sure I catch them all. So number one, get as much detail, obviously, about the facts of whatever it is, whether somebody got hit by a bus or a train or hit another car, and explain to the client why it's so critical that you have a thorough understanding of all aspects of the case, and let them know it's because you don't want, and they don't want you to be surprised at some point down the road. Maybe a month later, 6 months down the road, maybe a year, 2 years, or the night before trial, where some smoking gun pops up that nobody knew anything about. You really don't want that to happen, and it certainly does not benefit or help your client anyway. The next item for an injury case you might want to talk about, or will need to talk about, is medical treatment that was received as a result of the accident. Any medical or peripheral expenses that were incurred as a result of that, what your client's current physical and mental status is today, and how that has changed since the accident. Has it improved? Has it gotten worse? If they say it's become worse, is there any medical documentation that supports that claim? Those are the things that, again, while you're going to get information from the client, you want to verify it through the documentation, because the client may really genuinely believe that her symptoms are getting worse since 2 months ago when this accident occurred. But when you look at the medical records, they say Ms. Jones's symptoms have improved. She initially started out at a level 8 out of 10 on the pain scale, and now the pain at best is a 2 out of 10, and at worst it's a 4 out of 10. Well, that's very different from my pain's worse now than it was before. Obviously, there's an inconsistent statement there, and it needs to be figured out. Is maybe your client just didn't understand the question, maybe the medical records are incorrect, but something has to give, or else you're going to get that surprise that you don't want to get down the road. Is there anything that your client is incapable of doing today, now, that they could do before? So if your client was an avid golfer, tennis player, hunter, bass fisherman, won all kinds of awards and huge amounts of money by doing these things, or even things as simple as mowing the lawn, taking care of the trimming of the weeds, or all these things. If they used to be able to do it before the accident and today they cannot because of the accident, that's information that you want to know. Now, is the inability to do the things today that they could do before, is that related to the injury, or are there maybe other things that were, are there any pre-existing injuries or problems that they were treating for prior to the injury that could have had an impact on their ability to work outside, mowing the grass, playing golf, hunting, fishing, those kinds of things? And then also, because this happens all the time, you have a client that says, I can't do anything in the house. I can't cook spaghetti. I can't vacuum. I can't mow the lawn. I literally can't do anything. And then you look at the medical records, and the extent of the injury is that they have carpal tunnel syndrome on the right side. Well, a lot of the things that we just mentioned are things that you could still do even if your right side was not really in use much, or not, that you, for whatever reason, could not use it or had limited use of it. But certainly the other side, if it's not impeded, there shouldn't be a problem using your other side for vacuuming, I mean, you have to really ask follow-up questions when you hear something, and when you're looking at someone and they seem to have, they don't seem to have any outward impediments that you can identify, but they're telling you that they're just absolutely incapable of doing some of the most basic activities of daily living. You really want to follow up on that in terms of just ask follow-up questions. If someone says, well, I pay Jones Lawn Service to come over every week now, and I used to mow every week, but I can't do it. Well, you might want to verify that receipts from Jones Lawn Care, because you don't want a situation where the other side may have surveillance and sees that your client is out there on a big tractor mowing 5 acres every other week or every week, and those are things you don't want to have happen. So when you hear something that and you'll know intuitively, it doesn't sound quite right, follow up on it. Don't be afraid to do that. But that is important to identify things that people can't do today that they could do before. You just want to verify that it makes sense based on the type of injury. You would certainly want to inquire whether they had personal or problems with personal relationships that might include loss of consortium with a wife, a spouse, a husband, whatever. Is that been an issue because of the injury? You're certainly going to discuss the process of litigation, not just alternative dispute resolution matters, but you want to explain the length of time that someone can expect things to carry on during the pendency of a claim, and why, if they are not familiar with certain types of ADR, like mediation, negotiations, arbitration, why it's important that they learn about it, because it can have a valuable and significant positive impact on their case. It certainly might be able to resolve a case much more quickly and as we've said, much less expensively. But speak to them now when they're new and they're listening to you, and hopefully that they feel comfortable enough that they're really engaged and actively listening. So if you hear something that you can tell the client perceives as negative but isn't sure, I mean, you'll tell that. Encourage a candid discussion with the client of any potentially negative aspects of the case. And again, those are things that if you have tons and tons of single-space questions, you'll never be able to follow up in a copious enough manner to really do the follow-up necessary to find out what the problems are. Because if you sense there is a problem, there probably is a problem, and you need to know about it. It is a need that you have. Talk about the alternatives to litigation, which of course we've talked about: negotiation, mediation, arbitration, collaborative law. Just a few things that could be utilized to encourage a more timely resolution of the claim. And as we've talked about at length, identifying the needs, wants, and desires for settlement, which of course you'll want to really get into in some depth, and I get buy-in when you arrive at a BATNA, and explain what that is. And I mean, don't say BATNA, but explain what it is that you're working so hard to arrive at in terms of that BATNA and why you do that. And it's it's important for your client to know that you are putting in a significant amount of effort to make sense of your case and your particular situation, because if 10 other people had the same incident that you did, there would be differences in terms of the facts, there would be slight differences in terms of their presentation with injuries and other things. So, for your case, it's important to make sure your client understands how you're arriving at that BATNA. It's especially important when you go to a mediation or negotiation and there's you make a demand or an offer in the case to settle for way more than what your BATNA is, you need the client to understand that you don't really believe that you will not be getting that. But that's a high aspiration beginning point. It's a starting point. And don't be afraid to, a lot of lawyers, especially newer lawyers, seem to be skittish and sometimes just downright afraid to share their opinions based on experience with other factors that are germane to this process. And that could include things like whether, what is the nature of the county in terms of jurors? Are they conservative? Are they liberal? Are they somewhere in between? Having information like the percentage of votes that President Trump got over Hillary Clinton, just anything that can help you explain why you have concerns, or maybe you have high hopes about a particular county based on that kind of information. What are typical jury awards for similar type of claims? Over the past number of years, there are publications that have that kind of information that you can participate in and sign up for. And basically, the bottom line is just making the client feel comfortable so that if they have a question that you can, that they should be able to feel free to call you, and that you will do your best to answer it in a timely manner. Now, the sticky part with clients is when you decide to give a client your cell number. You really want to think about the practicality of doing something like that, because if you have a client that's involved in a highly intense situation where they're in a high level of distress and frequently distressed, high anxiety, things like that, you could end up in a situation where you get so many calls that you almost can't do anything else but deal with that. The other problem is every time they make a call, they forget that if you're an hourly attorney and billing by the hour, that whether it's 5 minutes on the phone or an hour and 5 minutes, that is going to start ticking away immediately, and it's going to start eating up a retainer, and it's going to result in large bills that the client may or may not be able to pay. So you want, as with all expectations of the claim and of the process, and really emphasizing a thorough background and helping your client understand everything that's involved, set expectations for the communication between your client and you. If you have a really skilled paralegal or secretary, tell them, listen, if you have a question that's just not a dire emergency kind of basic question, feel free to contact Jill or Bobby Sue and let them know what the question is. If they can answer it, they will. But if they can't, they'll come to me and ask me, and I can help to get you the information that you need. But you need to be careful about opening a floodgate. There's another use of that term, floodgate. But you want to be careful that you don't open a floodgate so that every day, every night, every weekend revolves around a certain person's phone calls, text messages, emails. I mean, it's, with the advancement of technology and electronics, that's all that we're bombarded with constantly, and it's to the point you don't even know what to respond to. So I think it's more about setting expectations that you may not call back immediately, that you have other cases, you have trials, you have preparation. Just exactly what you're doing for this client, you're doing for many others. So people will understand if you explain it to them in a way that they can understand. Attorneys have a problem a lot of times trying to be articulate and speaking at a higher level, because again, that's our training. But it's really hard sometimes for attorneys to kind of bring things down a little bit and just have a conversation like you would if you ran into someone at Kroger or at McDonald's. you'd be amazed at the difference just with that in making someone feel comfortable, not by patting them on the back or giving them a cheeseburger and french fries or a martini, but just having a conversation with them in a comfortable, informal, relaxed way that they feel that they can really talk to you and they really understand what you're saying, that you're not using a lot of $10 words that they have to look up in a dictionary, but you just present it in a way that makes sense, right? They can go home, they can tell their family, tell their folks, tell significant others in their life what you told them and how you explained it, and feel good about it, because if you do that, they're going to own that information and they'll remember it. And what you don't want is you don't want to spend a lot of time talking to someone about all this information and explaining the processes of litigation and about ADR for them to just turn around and then just go home and forget everything. That doesn't make sense. And most particularly, you want to make sure they understand and appreciate the why behind setting the expectation level about communicating with you and how that will or should work on a day-to-day basis. Because that will really help prevent a lot of difficulties for you in a lot of situations. So those are all important things. And again, that's just one outline that I'll put up on Twin, but it's just helpful to think about if you can extrapolate that to any other type of claim. You just want to think about the claim in the big areas that you want to make sure that you cover, and don't forget, because you will always hear information that leads you to more questions that you would not have thought of, and we'll make sure that you get as comprehensive of a background on your client as humanly possible. So it'll be really worth the effort to make a good outline, not be wedded to that outline to read every word of it, but use it as a resource, sort of as a guidepost, so when you've concluded the discussion, you can go back and you can mentally or physically check off these questions, and if there was something that you really don't remember if you asked but you think you did, it's okay to ask again and say, you know what, we've talked about so much information, I just don't remember if I asked you this question, and then ask it again. It's okay, it's fine. In fact, it makes you human. If you did ask it before, again, it's a way for someone to recognize that you're not afraid to be human and that you're like everyone else, and that's okay. So this is all kind of good to have these headings to think about, because this is exactly what anybody considering the use of mediation should consider in pretty much any area of law. And I would encourage you to use this in a that matrix type setup, just to pencil it in, just to I guess provide support or maybe debunk your theory that mediation is a panacea, because mediation certainly is no panacea. It is a substantial tool that is helpful in many scenarios, but it certainly is not a panacea that will solve all ills in the world. It has to make sense. It has to make sense because if you're not going to save time or money or the emotional drain of your client, well then really what's the point, right? So it's definitely something you want to take the time to go through and make sure it makes sense. If it doesn't, it's okay, because there's other forms of ADR that might be better suited to your client's particular needs and type of claim that he or she has. So that's why you want to go into depth on this, because as I said, there is a significant expense, and unlike negotiation, which really doesn't incur a great deal of cost, this certainly can, and at a minimum you're going to be talking about $2,000 to $3,000 when you factor in your time and effort. So